we're going to be reviewing torts. You know, I've been teaching torts to lawyers and law students for almost 25 years, first at various Southern California law schools, and now as director of Advanced College of Continuing Legal Education. I'm the author of Smith's Review of Torts. I'm the author of Smith's Review of Products Liability. I'm the author of the Finn's Multi-State Method. So you see, tort law is very dear to me. You know, the law can be divided roughly into two broad areas, substantive law and procedural law. Substantive law determines what a person's rights and duties are. Procedural law determines how those rights and duties are enforced. Torts is part of the substantive law, so it's a study of rights and duties. A right is a legal entitlement, something that's supposed to be done for you. A duty is a legal obligation, something you're supposed to do. So rights and duties are the counterparts of each other. For example, if I owe you $10, you have a right to collect it, and I have a duty to pay it. You might say that a right and a duty are opposites to each other. Some areas of substantive law consider the rights and obligations that exist between society and the members of society. If we're considering the obligations our society owes its members, we're looking at an area called constitutional law. For example, our society owes us a republican form of government. Our society owes us protection for our freedom of speech. It's all in the Constitution, and so that's the study of constitutional law. On the other hand, if we're considering the obligations that each member of society owes to society, we're looking at the criminal law. For example, each of us owes society the obligation of not killing other members of society. If we violate that obligation, we've committed a crime. The study of crimes, of course, is the criminal law. Now, the area of substantive law that's concerned with the obligations that members of society owe to each other is called the civil law. Sometimes we owe each other obligations because of promises that we've made. If we're considering those obligations, we're looking at the law of contracts. For example, if I've made an enforceable promise to wash your car and then I don't keep that promise, well, maybe I've committed a breach of contract. And the study of obligations that people owe each other because of promises that have been made is the study of the law of contracts. But we owe each other some obligations without regard to whether promises have been made. And if we're considering those obligations, the obligations we owe each other without regard to promises, then we're looking at the law of torts. For example, I haven't made you any promise at all, but if you ride in my car, I owe you an obligation to drive in a reasonable manner. And if I violate that obligation, I've committed a tort. So a tort is a violation of an obligation that one person owes another without regard to promises. Of course, some situations involve more than one area of law. Suppose, for example, that when you got into my car, I promised you that I wouldn't drive faster than 25 miles an hour. And then I went ahead and drove 85 miles an hour, and I hit a tree, and you got injured. I broke my promise to you, so maybe I've committed a breach of contract. The law of contracts is involved. I violated the obligation that I owed you without regard to a promise. Remember, I owed you an obligation to drive in a reasonable manner, so maybe I've committed a tort, and the law of torts is involved. I violated the speed limit, so I probably committed a crime, and the criminal law is involved, and the Constitution guarantees that I'll get a fair trial for my crime, so the constitutional law is involved. Procedural law is going to determine the way that criminal trial will be conducted. It's also going to determine the way you go about suing me for my breach of contract, for my tort. And so procedural law is involved too. But on these tapes, we're only going to be discussing tort law. Tort law, concerned with obligations that exist without regard to promises. Well, where do these obligations come from? Some of them are created by the legislature in the form of statutes, but most are derived from tradition. Some traditions that are as old as the Bible or older, as old as the Code of Hammurabi. which is even older than the Bible. But the courts keep these traditions up to date by interpreting them in light of our modern needs. And this combination of tradition and judicial interpretation is known as the common law. For the most part, that's what you're going to be studying in your torts course, and that's what we're going to be reviewing on this tape. And once in a while we'll talk about statutes, because there are some statutes that just about every state has. But most of the time we're going to be talking about the common law. And of course, the common law varies from one state to another because judicial interpretations of traditions vary. So we're going to be talking about general rules. Sometimes states disagree about what the general rules are. When that happens, we might talk about a majority rule, which simply means that more states follow that particular view, or a minority rule, which simply means that fewer states follow that particular view. And sometimes it's going to be important to know which side is the majority view and which side is the minority view, but most of the time it isn't. Bar examiners and law professors don't usually care whether you know which side has a majority at the moment, because that's liable to change in the space of a year. So most of the time it's good enough just to say some states see it this way and some states see it that way. Now, as we examine the law of torts, there are three factors that we're going to have to consider every time. These are the three factors that every torts problem is based upon. When you're thinking in terms of exams, you can think of these as the three fountains from which issues may spring. We're going to cover them in detail as we go along, but I'm just going to make a mention now. First, basis of liability. Basis of liability. There's no tort unless something has done something for which the law might be willing to hold him liable. There must be some basis of liability. Sometimes a person is liable in tort because of fault, so the basis of liability is fault. But sometimes the law of torts imposes liability without fault, without regard to fault. When we talk about bases of liability, we're going to talk about three kinds of fault: intent, negligence, and aggravated negligence. When we talk about basis of liability, we're going to talk about special situations in which liability is imposed without fault, and we call that kind of liability strict liability. Okay, basis of liability is the first fountain from which issues may spring. The second fountain is proximate cause and damage, because with only a few exceptions, and we're going to talk about them, tort liability is not imposed unless the plaintiff sustains some actual injury, some actual damage, and shows that the damage was proximately caused. That's a legal expression that we're going to spend some time on. Proximately caused by the defendant's conduct. Now, proximate cause can be a very complicated concept, but when we get to it, we're going to try to make it as simple as we can. That's the second fountain, proximate cause and damage. The third fountain from which issues may spring is the area of tort law known as affirmative defenses. You know, anybody can say, when somebody accuses me of something, anybody in my position can say, I didn't do it, I didn't do it. And in general, we refer to that as a defense, but that's not what an affirmative defense is. An affirmative defense is a legal argument that says, even though I might have done it, and even though that is usually a tort, in this particular case, it's not a tort because some special rule of law allowed me to do it. An affirmative defense. For example, if I deliberately hit you with a stick, that's probably a tort. But if I can show that I was acting in self-defense, I might not be liable for that tort. So self-defense is one of the affirmative defenses we're going to look at. Now, we're going to be looking at each of these factors in turn. We can only study one thing at a time. Basis of liability, proximate cause and damages, affirmative defenses. But whenever we're on one of them, it's always going to be important to remember that there are two other factors also. You can't put all your eggs in that one basket.
There's 8 preemptive strikes on the in the case of a civil suit, civil procedure. That means 8 juries can be knocked off, asked to basically remove themselves from the jury. And this can be done because there's not enough men on the panel, or not enough women, or racial division and whatnot. I'll go back to the tape on the next one. So this is part 1.